going to introduce our first panel. The first panel is a panel of attorneys here today to talk about gun laws of the past, gun laws being proposed, and what's going on in the courts to fight these unconstitutional laws. So our first panelist is Daniel Modafferi. He's a graduate of the University of California Irvine School of Law, works for local law firm Myers, Fosey, and Dwork, where he specializes in litigations involving municipalities and law enforcement. He's a proud member of the San Diego Federalist Society. Please welcome Daniel. Also, please welcome John Dillon. He's a graduate of Loyola Law School in Los Angeles and an associate with Gatsky, Dillon, and Balance, where he specializes in Second Amendment issues and California gun laws. John is also special counsel for San Diego gun owners. Next is Jason Davis. He's a graduate of Loyola Law School, where he started the firm Jason Davis, headquartered in Orange County. Jason has worked on many high-profile lawsuits in California, has many high-profile clients, including the NRA. Jason is legal counsel for Poway Weapons and Gear. Jason. Finally, I'd like to introduce Alan Chandler. He's a graduate of Gonzaga University School of Law and is the Director of Legal Operations for Firearms Legal Protection. Alan is a former JAG officer and retired Army Lieutenant Colonel. Alan, welcome. As I said earlier, we're going to throw some questions at him, a few jump balls, and then we'll ask him specifically. Keep track of some of your questions. There are some mics around here, so we'll leave a few minutes for your specific questions. So let's jump right in. First question is a jump ball for all of you. What California law in place now, or law that is being proposed, is the most detrimental for gun owners? Starting off nice and easy.
Just go in order here?
Sure, I'll
Jump ball.
I would say, and it may not be, just a threat to gun rights specifically, but to rights generally, First Amendment, potentially even Fourth Amendment. The notion of taxing people for exercising their rights. There's a proposal in the legislature right now to increase the taxes on purchases of firearms and ammunition. It's being sold as instituting a tax as if there weren't one before, as if we don't already pay a dross fee every time we buy one, as if there aren't federal taxes and sales taxes and everything else. So the proposal is, if you want to buy a firearm or ammunition, pay us an extra tax, and supposedly the tax money is going to go to fund increased security at schools and other soft targets to ostensibly prevent shooting events. And the notion of taxing people to exercise their rights, I mean, it reminds me of the mafia protection charges, where they take something that's statistically unlikely to happen and make you really fear it and say, well, you don't want this bad thing to happen, so we're gonna make sure that we protect you, but you got to pay us a little bit just for our trouble. And I think that's a threat to your Second Amendment rights as well as a number of other rights.
Yeah, I agree with everything Danny said. On a specific level, I think one of the major issues in California are 5150 holds and gun violence restraining orders. Like Danny said, these don't just have to do with the Second Amendment. You also have, Fourth, Fifth, Sixth Amendment rights that are potentially violated due to these orders. A lot of them do not require a high standard of proof before a search warrant can be issued on your house. Police can enter your house and confiscate all your firearms and ammunition before you're even made aware of anything restraining order against you. So these ex parte restraining orders are, they're surprising. People don't know they have them until someone's kicking down their door, and they can be very dangerous. There's a lot of due process issues when it comes to this type of stuff. And they're also modeled off of the domestic violence restraining order that we have in California, which is just rampantly abused. This is actually goes to another question during the panel. I'm sure we'll talk to more, but it's usually the first thing that a divorce attorney or a family law attorney does when you're in the middle of a divorce is you try to get a restraining order on your ex-spouse, and those have significant implications. So gun violence restraining orders 5150 holds, which is the mentally ill or mentally defective hold for 72 hours. It's based off the judgment of the patrol officer who's got the call to check out what's going on. And again, you are immediately prohibited person based off of these holds, and it's then on you to fight for your rights to get those back. And I think they can be very dangerous in California.
I agree with that as well. I'm wanting to say that I think the most dangerous law out there is the one that allows the California legislature to be full-time, because all they get to do is just sit there all day long and just make up stuff and get paid for a job to make up stuff and figure out how to regulate firearms. But I'm gonna punt on this a little bit. I'm gonna say conceptually the thing that I think is the most dangerous is the fact that they're using marketing media as a way to regulate. And the way they do that is instead of just saying, here's the issue, we're trying to resolve it, they'll create a term. Like back in the 80s, they created the term assault weapons. And they said these were assault weapons over here, so everybody wants to regulate assault weapons, and they'll use machine guns as an example of what it is, even though that's not what it is. And then a few years later, they'll say, oh, well, these are also assault weapons, and just keep sweeping under the rug under the same banner, because everybody's already got it ingrained in their head that these assault weapons are fully automatic, or, as was said earlier, fully semi-automatic. But as they keep sweeping these under the rug, you keep getting these decades and decades of just bad media attention, mislabeling what they are, and at the same time expanding the term as to what it means. So now it includes the most common guns in the United States, and everybody in all the legislature in California is just frothing at the mouth to get rid of this because they know that these are popular firearms. Same thing for unsafe handguns. We say, well, who wants an unsafe handgun? Nobody wants an unsafe handgun. But then when you actually look at the law, you see what they're actually doing is they're saying unsafe handguns are, well, this gun's safe, but they didn't pay a fee to add this color.
Is that the blue or the silver one?
Yeah, well, no, the green one's okay.
I was just going to say, I think there's a few unsafe handguns that are on my list that I'd like to get.
So they just keep sweeping these these different firearms under these terms that, on the face, it sounds like something everybody should support because nobody wants to buy an unsafe handgun. But when you find out what it actually really is banning or prohibiting, I think that's extraordinarily dangerous, and it's the use of their marketing in legal terms. I think it's one of the most dangerous things.
And I'm going to agree with all of that. I traveled to about 30 states, I think, last year, looking at different gun laws and trying to put my arms around them. You go to a place like Idaho where they have like 40 pages and that's it. You go to Michigan, they have 680 pages of firearms laws that are contradictory. So you really need an attorney up in that area. And then you come down here and you find that the more complicated they make it, the better it is for them. I mean, I had to have a flow chart to go back and forth to figure this, to that, the other thing. You're being legislated to death here, literally legislated to death. 4 of us are trying to figure out exactly, is this, the 80% rule, how does this work, how does that work? It's crazy. It's like a board game. I feel like I'm playing Monopoly with your rights, okay, and that's crazy. And in addition to that legislative overreach that California's doing, there are 2 things that have been around for a while that they're really starting to pull in now. One is the Landerman-Petrus Short, or the LPS Act. It was a 1972 act. Landerman-Petrus Short, LPS. And it was a way of people being hospitalized if you have a mental illness, okay? And that's what these guys were alluding to earlier. It's a 72-hour hold, and all it takes is a healthcare professional, doesn't even require a doctor, or a police officer, just say, I think you're a little unusual today. And so we're gonna put you away for 72 hours, and we're gonna evaluate that. And you have very little rights for the first 72 hours. And then after that 72 hours, they can hold you for 14 days. But they do give you rights because you have the reasonable right to make a reasonable phone call, whatever reasonable is. And that's determined by the institution that they put you in. And then you can actually get wrapped up and we're going to cover this in more detail with question number 2, but you can be put away for 6 months. Wow. And you're like, well, how did this happen to me? Well, the police officer felt that you looked a little crazy, and we just took you down that road. And the more angry you get when you go down that road, the closer you are to getting the 14-day and then the 6-month, and it's like suddenly it's Nurse Cratchit. Okay, so I worry about that. And the second thing I worry about is 25850G. Okay, and 25850 is talking about what a loaded firearm is. It's like, what's a loaded firearm? Well, in California, which is unusual to me, is like if I happen to have ammo in one hand and a firearm in the other, it's loaded. Okay, well, that's interesting, okay? And so that's a loaded firearm. Wow, that's a great way to write that for the legislature and for everybody else to figure it out. Okay, that's not loaded in any other state that I'm aware of. Okay, but it is here. And so if your neighbor says, I think you had a loaded firearm, I'm going to call the police to see if we can verify that. The police don't even have to verify. They can come and actually arrest you based on your neighbor saying that under 25-850G. Whenever the person arrested had violated this section, although not in the officer's presence, okay? Whenever the officer has reasonable cause to believe the person to be arrested had violated this section, whether or not the section has in fact been violated. Wow. So I worry about, the over-legislation of gun laws in this state. And that's, so looking out over the battlefield, because I was in the Army 20 years, right? Looking out over the battlefield, I worry about the over-legislation of all these gun laws so that we get to the point where nobody understands what the heck they are. You have to have 4 attorneys try to figure it out. And then you, the regular individual, who's I just want to be able to defend my family, is caught in the crossfire, as it were. So that's my greatest fear. And I'm licensed in Texas, which, by the way, welcome to Texas, here's your firearm, and California. So a little bit of difference. Thank you.
I just want to clarify one thing real quick. Loaded firearm has multiple definitions. The definition he's referring to is if you're actually in the commission of a crime. But generally, it's People versus Clark says that it has to be, the ammunition has to be in a position from which it can be fired. So that's the general interpretation, but it does go to be as broad as what he said earlier under specific circumstances.
Jason, back to actually a situation I was talking to you about, one I became familiar with recently. A gentleman.
You're waiving privilege.
I'm sorry?
You're waiving privilege.
Well, okay, well then we won't get it. So let's just go into this. I'm putting that through my head real quick. Going, okay, whatever. All right.
It's hypothetically.
Well, hypothetically, there has been stories out there that a person goes in, is having stressful life, goes in to seek some help, goes to the hospital and says, I just need to chill out for a little bit. I just want to talk to somebody. And hypothetically, I've heard that people are then being put in a 3-day hold, and when they come out, they won't even be released until they sign a document that says they were in that 3-day hold and they're waiving their rights to firearms. Are these things happening? And I guess I'll just follow that up by, what are we doing in California? What are you doing to deal with those processes?
So, yes, they're happening. The document that they're signing is not what's prohibiting them from possessing firearms. The document is a notice saying that the hospital has provided them with notice that they're now prohibited. The way it works is if you're taking in on a mental health evaluation for being a danger to yourself or others, you automatically lose your rights for up to 5 years. And I say up to because you can go in there earlier and get your rights restored, but it's generally a 5-year ban and it's automatic. And there's no due process. It's literally, it's what, if the doctor admits you or the nurse admits you, done. As long as it's for danger to self or others. But if you stay there for more than 72 hours because they have determined that you are a danger to yourself or others, you get what they call a 5250, and that's a lifetime ban. And under California law, you can restore your rights under California law, which sounds great and dandy, but what they don't tell you is the federal law is a lifetime ban. So even though you've restored your rights under California law, the way that you restore them under California law does not satisfy the federal requirements to restore your rights federally. So it doesn't matter what state you go to after that, you're prohibited for the rest of your life. And the only way you can get them back is if California ever changes their law so that it can comply with federal requirements, which they may be doing, but I don't know if that's still going to be on their plate given the last couple of shootings that we've had. But it is something that's very disconcerting. And I think that the more disconcerting part about it is not the 5250 itself, but it's how broadly people are being scooped up into that net. I've had clients who have been fired by their friend who's working at the facility, and all they do is say, "Oh, I wish I was dead." Okay, and they get up and they leave. Well, they just got fired. It's more of an off-the-cuff comment, but that comment is enough to make HR say we need to report it, and that reporting allows the police to say we need to bring SWAT down there because we know he has lots of guns. They go in there with SWAT, they take him, he loses his rights. Now a judge has to decide whether or not he needs to have his guns back. He had a 5150, and he has firearms. And the judges are going to be very cautious and very conservative about whether or not they want to restore somebody's rights, and I think the politics that's currently going on right now is just making that much more difficult for the person who had a bad day to get back on track. Whereas there are definitely needs and reasons to have that. You know, if you have someone who actually is a danger to themselves or others, you don't want them to have a firearm. But the 72-hour hold is not because you are a danger to yourself or others. It's an evaluation to see if you are a danger to yourself or others. So it's kind of one of those weird, we're taking your rights, and you have 5 years to get them back if you want.
I want to put a point on that from Pennsylvania, because we had an individual who had served in the military for 10 years and then was a Pennsylvania State Patrolman for 10 years and then decided, well, I'll just buy my own weapon, because what the heck. So he wanted to, and it's like suddenly he was under arrest in Pennsylvania, felony, because back when he was 17 years old, he was placed in a mental ward for 3 days. He's like, what? And so Joshua Prince, one of our attorneys, went and retrieved the records, like, what's going on with this? He's like, and come to find out when he was 17, his mother had lost her job, single parent, and had taken had some medical issues, and the only medical area was a mental facility and a medical hospital. So he stayed there for 2 days, maybe 3 days. And so that was enough for a lifetime ban under the feds. So that had to be fought, and you fight it at the state level to get to the federal level, which is also a little bit unusual. I don't know if you guys have the same thing here. So that was overturned by the state of Pennsylvania, but it took a whole lot of appeals process and about 18 months and an awful lot of money. Okay, now, I lived in California for 5 years up in Sacramento. That's when I took the bar exam in 2009. I've been a Texas attorney since '86. So I left here, not that it wasn't gun-friendly and not that I didn't like people in the military, but I went and took a job as a prosecutor in Dallas County trying to do capital murder cases there. And while I was there, friends of ours visited from California. And my son is putting him upstairs, and they're having fun playing video games. And every hour and a half, his mom is calling from California. Is everything okay? Is everything okay? And the kid's like, yeah, everything's okay. So this goes on about 5 times over a period of about 6 hours. Finally, my wife's like, what's going on? And so they asked the question, and it's like, well, Mr. Chandler has guns. Now, if I had been here in California, I'd be on a 72-hour hold, okay? And you know, it's valid. So, and we'll talk a little bit about more of that in a little bit, but you have to be really, really careful, and we need to work on that. So it's awareness. That's why we're doing this, I guess.
Okay, so that was just a scratch in the surface. Let's go for a deep dive. So John Dillon, let's dive into the 80%ers. It's going to be a big topic the rest of this year. But what are the California statutes regarding and regulations regarding home-built 80% firearms? When do those restrictions go into effect? How do you keep your home-built firearm legally?
Okay, so we're going to be here for about 3 days. And so go to the bathroom now, get out your notepads.
You move.
So most recently, we had AB 857 pass, which enacted new regulations on home-built firearms, meaning firearms that people made themselves for personal use. Usually it involves an 80% lower when you're discussing AR-15 style rifles or even pistols. Also, there are handguns that there's multiple variations of handguns. 1911 platform and Glock platform are the newest versions of all this. So essentially, prior to 2016, you could make your own firearm for personal use, and it didn't have to be registered with the state of California. Once AB 857 passed, starting after July 1st, 2018, if you plan on assembling or manufacturing a firearm, you have to obtain a unique serial number from the state of California, DOJ, before actually manufacturing that firearm. And so again, you have not built anything yet. You just want to build something. You have to apply to the state in order to do so. They will, you send in, you apply on CFARS, which is California. What do we got? What's the acronym now for the
Firearm access.
Yeah, I have it written down here.
California Firearms Accessing System? It's basically.
I have my
Right
own
here.
acronym in my head for it.
Yeah, California Firearms Application Reporting System,
There you go.
CFARS.
CFARS. So you will be going online, and you will be clicking on a unique serial number section, and you will fill out those forms indicating all of your personal information, name, birth date, home address, driver's license, all sorts of information on a personal level. They will run a background check on you to determine whether you are eligible to own and possess firearms. At that point, they will issue you a unique serial number, and you have a limited amount of time to get that firearm engraved with that serial number according to the firearm marking requirements on federal and state level when it comes to the depth of the engraving and the height and type of font you use.
And the information that you put on.
Yeah, and the information you put on there. So, and I believe the the timing on that is 10 days? 10 days.
10 days, yep.
So you have 10 days to do that. So if you have a job or family life that takes up a lot of your time, you're going to have to put that on pause because not everyone here has access to an engraving machine, at least I don't think, that can do these types of engravings. They're quite expensive generally. So you'll have to do that. And then after you have engraved all this information onto that firearm, you then have to show and prove to the state of California that you complied, which they will be requiring multiple digital photographs to be submitted, showing the entire firearm on both sides, as well as all of the markings on the firearm. And at that point, you've now entered the centralized registry when it comes to firearms, so that firearm is registered to your name. It's in the centralized list in California. And that's if you want to plan on making a firearm after July 1st, 2018. Now, anyone want to jump in on if you've already made 80%?
No. But it also says
That's what I thought.
yeah, you have to apply in advance, which is really crazy, and they're going to give you a unique serial number or other identifying mark, like you were talking about. Like, what's the other identifying mark?
Well, generally speaking, it will be the make and model of the firearm, which, since you're building it yourself, you would have to make those up. The manufacturer, which is going to be you, so John Doe made the gun, so that'll be inscribed on the firearm, and usually the city and state where the firearm was manufactured, along with the unique serial number. So it's not just taking your Dremel and scratching in some numbers. It's a highly involved process, and it needs to be done accurately.
And I'm sure the ATF is going to love the fact that you're now marking firearms, so we're getting into the manufacturing.
Yeah,
without
I don't know
license.
how the state of California is even going to be getting away with issuing serial numbers. I haven't heard anything yet on if ATF has coined any opposition or problem with that, but that's generally a federally controlled thing there. So,
But just if you mess it up, it's a misdemeanor right off the bat. You did it wrong, it's a misdemeanor, according to the statute. So.
Can I just point out one thing real quick? The DOJ and the regulations, and in, even before the regulations came out in their letters back and forth to each other, referred to these homemade firearms, instead of calling them homemade firearms, they called them FMBUS firearms. FMBUS stands for Firearms Manufactured by Unlicensed Subject. So I just wanted to point that out because they see us as subjects, not as citizens or
individual person,
people.
yeah.
So just as a heads up, that's the agency we're dealing with, is someone who looks at firearm owners and people who make their own firearms as subjects. So
And now, if you remember that whole process I detailed there, which I even generalized some stuff, if you already own a firearm that you built by yourself, and after July 1st, 2018, you have to apply for this unique serial number and have it engraved on that firearm, and that needs to be done before January 1st, 2019. So even if you made a firearm and you've had it for a while and you did it, legally compliant, following the law, you will have to get a serial number for that firearm, and it'll have to be registered to you unless you fall under a very strict couple exceptions.
and I want to point out that it also applies to firearms that you did not make, but that don't have serial numbers on them. There are exemptions for antiques and curios and relics and certain other firearms, but even if you didn't make it yourself, you still have to engrave these numbers on it and go through this process if it doesn't have the serial numbers on it.
Yeah, now antique's still $18.99 here, right?
$18.99, yes.
$18.99.
So let's get into something that I'm sure is less complicated. So let's talk about bullet button ARs. I'm sure everybody here has run out and registered your existing bullet button AR, and of course you found that first you have to register yourself before you start registering your firearm. We've told people to be cautious on doing that up until the very last minute, because gentlemen up here and others are working diligently trying to help us out with those laws. But let's get into, what is the current required registration process if you're registering your bullet button AR as a assault weapon. There are a lot of products being marketed as well that we have some examples of here, but what's the overall process?
Well, the process for the registration itself is very similar to what John was describing for how you get an individual serial number. I'll repeat what I said. The process itself for registering an assault weapon is very similar to what John just described for obtaining a unique serial number. It's an online application system. You give them all of your personal information. You send them digital photographs of your firearm. They approve whether or not they think that that firearm looks like one that they want to allow to be registered or not. If they don't think it looks right, you may get some DOJ agents knocking on your door and asking to inspect the firearm in person. We'll get into what qualifies for needing registration and how you can avoid registration, but that's the process itself. Is you have to go online, you have to pay the fee, you have to give them all your personal information, and send them photographs of your firearm so that they can determine whether or not you've complied with what they want to see in terms of your bullet button and the style of firearm that you have and so forth.
Make up a new password when you give in all your login information, just as a recommendation. You don't want to use something that you use on other email accounts or bank accounts or anything like that, because if you're giving it to the government, you're basically saying, here's how to access all my stuff without a warrant. So.
Well, and the pictures you're sending in, from what I've seen that they're asking, you're sending pictures of the entire firearm, every part of it. So one could theorize that once they have that picture, and based on the letter of the law, if you break that optic that you had on there, or you want to change out your forearm or the forend, you're kind of stuck.
There's only a restriction that you can't change the bullet button itself. And I think the way it's worded, it actually applies to that kind of a device. It doesn't mean that you can't put a different one on it if it's the same brand or same make or model. But there's nothing that prohibits you from changing out other parts on the firearm.
Okay.
I think they're supposed to be I think they're doing this so that they can verify that the firearm was an assault weapon under the current law, or is an assault weapon under the current law, and would have not been an assault weapon under the previous law.
One of the requirements to be able to register, so-called assault weapon under this new registration scheme is that you legally owned the firearm before January 1st, 2017, and it would fall under the bullet button style rifles where they have the evil features of so-called assault weapons, such as pistol grip, forward vertical grip, collapsible folding stock, but it had a bullet button on it, which met the then current definition of a fixed magazine. And you had to own that gun in that format and style with those parts assembled onto it before January 1st, 2017. And part of the registration process, you actually detail what features you have on your rifle or pistol or shotgun that would classify it as an assault weapon. And that's also part of the reason why they're requesting those pictures, because they want to compare the pictures with your description in your application.
So what kind of features, let's walk through this for those people who may not know, but how do we know if they're legal, and what can we do to make them a feature of this rifle? We have some examples up here that when we have a break, people can walk around and look at, but why don't you walk us through it?
Well, first I'd just say the best thing you could ever do is get the law in front of you, get the regulations in front of you, and take the time to sit down and read that. I can't tell you how many people that own guns, don't own guns, that just have never even read the law. They go on forums or they go on news organization sites and they get the summary of the law, and they don't actually sit down and read the text that is really going to be affecting them.
But Patriot 325 said it's okay.
Exactly. So although forums can sometimes provide good information, do not obtain your legal advice from an unknown internet source. So read the law. That's the first thing. And after you read the law, do your best to try to understand it. If you don't understand it still, find someone who has expertise on this level. If you need to and you really want to be cautious, take the time and spend the money to talk to an attorney on a formal basis and get a professional opinion on that. Other than that, generally speaking, the gun community is pretty good when it comes to compliant products. Everyone stays pretty up to date. YouTube is a great way to, once you read the law, you can look up a certain product and see how it's supposed to function. A lot of these compliant products will show, how they function online, so you can see that, compare what you see, how this the product works to the law that you just read. Unfortunately, DOJ doesn't like telling people what things are in fact illegal. They just like to tell you what things are illegal. And it's usually after you're already talking to a police officer that they'll tell you it's illegal. So that's the dangerous part about that. You're never going to get the DOJ to say, hey, all of these products are good to go, and get you around all the regulations that we just tried to impose on you. So
I don't like using the word around, but it complies with the
complies
regulation.
with, yeah.
Tell them your story about the police officers gathering at the gun range where you had to explain what that's a great example.
Well, a good example, of how people don't read the law is I have clients all over San Diego, FFL clients, and I was stopping by one of those clients' stores and just to say hi, see how things were going, and I turn around and about 10 to 15 CHP and sheriff officers start walking in. I, being who I am, I turn around and look at the owner saying, what did you do? I go into panic lawyer mode. What do I got to do right now to save this guy? But in fact, this was before the assault weapon laws took effect. There was a bunch of law enforcement officers who had no idea what these new assault weapon laws were. They had no idea how to comply with them. They didn't even know what an assault weapon was. So they came in truly to ask, what are we talking about here? Because we all own guns at home, and because we're law enforcement, we generally don't have to apply the same rules and laws that you guys all have to comply with. And they went into panic mode saying, all right, well, my son's 18, is he allowed to buy a gun? How can he buy a gun, before this law goes into effect? And I spent about an hour and a half with, 10, 15 officers detailing the law and talking about the laws that are about to go into effect and how they're going to affect them. And it's just a good example. Even law enforcement is woefully ignorant on the subject. It's really bad. They're writing these laws as they go. And that's when you see all the contradictions. That's when you see the giant gaps in the law that make no sense, and that's when people get into trouble. That's when people make mistakes because they assume one thing or assume something's legal or illegal, and then they go to the range and they get law enforcement officers there too, just on his free time, but then he sees something that doesn't comply. And remember, law enforcement, it's not their job to determine whether or not they were right about if that gun's illegal. In their opinion, if a gun is illegal, it's their job to enforce the law as they see it. It's the attorney's jobs afterwards to figure out whether or not that gun was actually legal or not. So sitting there and talking to the cop saying, oh, no, this is why my gun's legal because of all these things, it's never going to help you. You do have that right to remain silent. We all suggest you use it in situations like that. But it truly is. Their job is to enforce law, not make the interpretation and decide whether or not you're good to go.
So, Alan, let's shift gears a little bit. AWR brought up the point of the Concealed Carry Reciprocity Act. Let's talk about that and what the likelihood this bill will affect the rights, under California law for gun owners. Yeah.
I think it's dead in the water, actually. It's a great idea. We're talking about H.R. 38, the Concealed Carry Reciprocity Act 2017, H.R. 38, for those who are writing it down. What the bill was supposed to do, it was supposed to allow any person who wants to carry a concealed permit from one state to carry that weapon into another state and have the same license. So you can go all the way from California to New York, down to Florida, up to Minnesota, and you're good to go. As long as one state would give you the concealed carry license, you're good in all of them. If something's going to be that simple and that good, it's not going to pass, okay? As soon as we had these shootings and so on, everybody, they threw that out. Just like silencers. When they had the shooting in Las Vegas, we were ready to pass the bill on silencers. First thing that the media did, as soon as the shooting occurred, they went on TV literally within an hour and said, we got to stop silencers. That had nothing to do with Las Vegas, okay? So anyway, the Concealed Carry Reciprocity Act of 2017 looks like it's dead in the water. It's going to be hard to do at least this year. We'll see how the elections go next year. That's my overall view anyway.
And even if it did pass, for many of us in California, it really would have been worthless. If you're in one of the counties where they don't issue, you have to have a CCW from your state, and you have to get it in California from the county that you reside in, or there's temporary ones you can get from counties that you work in. But if you're in Los Angeles County or San Diego County, it's still going to be very difficult, even if it did pass, to be able to get one. So,
yeah, it's really mostly for all of us visiting you.
yeah.
I think originally,
We're here to help.
Originally, when they were discussing this and first proposed this, there was some discussion about allowing out-of-state CCWs to then count for you. So if you went and had an out-of-state Arizona CCW, you could possibly carry in California due to reciprocity. The way it's written now, in the most recent version I've seen, that is not in fact the case. So even if it passed, like Jason said here, it's not going to help you unless you have a permit already. And in counties like San Diego, San Francisco, LA, good luck.
And even if it were to pass through the legislature, then you're still going to have a fight in the courts. There's going to be all of the anti-gun groups are going to be filing lawsuits in every liberal court they can find and trying to get this law struck down. And I guarantee you they'll find you some court that'll do it, and it'll wind up getting fought out up until the Supreme Court. And maybe the Supreme Court takes it, maybe they don't, but that's going to take a really long time. And lately they don't seem to like taking Second Amendment cases at all.
Yeah, if
Remember, you're in California.
Yeah, if you want to pass something that's really pro-Republican, they go to the Fifth Circuit. You want to pass something that's not, and it's liberal, they go to the Ninth Circuit. And guess what circuit you guys are in? So there's been a couple of things like immigration. When they disagree with it, they go to the guy in Hawaii. Yep. It's like, we're going to go to the judge in Hawaii, and he can take care of all 50 states from Hawaii. So that's something that maybe needs to be addressed also. But anyway, so yeah, it's going to take. The last vote was 231 to 198. That was before the last shooting and all other good stuff. So they've tabled it.
So Jason, let's talk about something that applies to everybody in this room. There's a lot of misconceptions out there, and I think it's incredibly important that we continue to educate as much as possible. But explain where California falls on the Castle Doctrine or the Stand Your Ground law, and what's the difference?
Castle Doctrine basically gives you a presumption of reasonableness when you defend yourself in your home. And the Stand Your Ground Doctrine says that if you're trying to defend yourself, you don't have to flee if outside your home. I guess it could apply inside your home as well. California does actually have statutes and or case law on point for both of those. With regard to the Castle Doctrine, we have Penal Code Section 198.5, which basically says that presumption applies here in the home. And then there's a case called People versus Clark, which says that you don't have to flee. So we have both of those, despite the fact that the news media like to play it up that this is such a strange thing that happened in Florida a few years ago. We've had it for years. So.
Okay.
Yeah, California actually has a pretty good Castle Doctrine compared to certain other states, which shocked me when I was looking at it, because we have to go look at all these. But Castle Doctrine literally is just like he said. It's your home, and Stand Your Ground is away from your home. But the real difference is whether you have to retreat. And what that means is if someone comes at you, do you have to leave, try to escape the anger, the force that's coming at you? Do you have to leave the force that's coming at you and then come back, or be unable to retreat? So like if somebody comes into your house, do you have to leave your house before you can actually engage them?
And even though there's a presumption, it's a rebuttable presumption, which means if there's enough evidence that shows that it wasn't reasonable, they can still come after you. So it's not like a get out of jail free card. If something happens, you still have to have enough evidence there that shows that you that they can't overcome that presumption.
A good example is if you wake up in the middle of the night and there's a 14-year-old kid in your living room with the TV in his hand and he's walking out your front door, and you pull out a gun and shoot him, it's going to be that presumption that you were in a reasonable fear of your life goes away real fast. Because yes, it's presumed one way until the evidence of a 14-year-old kid with no weapon walking away from you was in your house. There's no reasonable fear at that point unless has a knife in his hand screaming that he's going to kill you. Like you said, it can easily be overturned according to the circumstances. So it's not a get out of jail free card. It's not a solid thing that, oh, no, they're in my house, I can do whatever I want. That's just not true.
And that's the same thing with stand your ground. Just because someone is the initial aggressor toward you doesn't give you carte blanche now to go ahead and kill this person. If they initiate aggression toward you and then they start running away, there's no longer an imminent threat to your life. You can't use deadly force, whether there's stand your ground or not.
Yeah, just about every state, you have the right to use reasonable force, which is physical force. Like if I'm in his house and I don't want to leave, he can escort me physically by touching me to move me. You can use reasonable force up to and including deadly force. If you're greeted with deadly force, then it's imminent. So what that means is deadly force has to be in your face and it has to be imminent. Okay, it's not like I had deadly force, it went away, and now I can shoot somebody who's leaving, right? So deadly force has to be there and it has to be imminent. And California defines deadly force pretty much the way most of the other states do, and that is that which can kill you or cause serious or grievous bodily injury. I'm not talking about like a hangnail, but I'm talking about like a broken arm or a bashed in head or those type of things that are serious physical injuries. It has to be that kind of, it has to raise to that level, not a belief that it's going to happen, but an actual, it could happen. Does that make sense, everybody? Okay.
And to touch on this, we've used the term reasonable a number of times so far. When they're trying to figure out, if what you did was okay or legal, it's based on a reasonable person standard, which is going to be judged on an objective and subjective reasonable standard, meaning objectively or subjectively, you as the individual, you were in fear for your life. You can prove that, but if a jury group of ordinary citizens determine that, yeah, he may have believed that he was in jeopardy, but no one else in the world would have, you're going to be in the world for hurt there. And it has to be a true, reasonable feeling of imminent threat or danger, or imminent threat of great bodily injury or death.
Okay, well, I have a list of questions here, but I think in the interest of time and keep us moving forward, if there's any questions you want to ask this panel, let's open up to some questions. And then we're going to take a short break, and then we're going to bring the new panel up and keep going forward. Sir, either yell it or there's a, okay, well, I guess we'll go with him and then you, sir.
Hi, I had a question about the registration and what you guys were touching on earlier about bullet buttons being able to be replaced, but only with bullet buttons. So if I do register my AR, I cannot put anything else on there but the same type of bullet button. I couldn't put a regular button on. I couldn't put a rad lock on or something like that afterwards.
The way the law is worded, did everybody hear the question? Yes. Okay. The way the law is worded, or the regulations worded, it says that you can't remove the bullet button. The intent is basically they're trying to stop people from going back to the standard release magazines. It doesn't really necessitate that you can't replace it. I just think that when it comes to law enforcement investigations, let's just say you're stopped on the way home from the shooting range, if they happen to be able to get access to that and they say, no, he had this kind of a bullet button on it, that would imply that maybe you did remove it if it's not the same kind. Even though it may have been removed in maintenance or repair, and it may have been removed when all the features were off, because a lot of this has to do with the order you remove stuff too. I think that just from a cost-saving standpoint, meaning I don't want you to have to hire one of us to defend you because you got a different button. It's best to just use something that's similar to what you actually registered in. Thank you.
Hey, want to thank you for your time. You've made it clear that guns are for cops and criminals in this state. Yes. Okay,
And legislators.
Yes, there you go.
And legislators.
Two questions on 80%ers. There's some rumors floating around of different ways of putting a serial number on it, but you guys are delivering the message only the ATF can issue a serial number. There's no other numbers or any time or before or after build. That's the only number that you can engrave on a weapon.
The DOJ will issue you a serial number upon you submitting your request for a serial number, and that's the number you have to install on it.
Right, and there's no other number, no other way of doing that to be compliant with anything, depends on dates or times. That's the only number that can be put on there.
Yes.
Okay, that's how I read it, but there were some other feelings in a gun show, and it didn't make sense to me. Second question, you have an 80%er. You decide, you know, I want to comply with the law. How do you disassemble an 80% weapon to be compliant that it is no longer a weapon? How many pieces do you have to make it so that you're not a criminal?
Can I, 80% implies that it's not a firearm to begin with, just for clarification purposes, so it wouldn't be 80% in and of itself is not a gun, let alone, can it be an assault weapon? Because it doesn't it's not, in order to be an assault weapon, it has to be a semi-automatic rifle or a semi-automatic pistol of certain criteria, and an 80% in and of itself is not. But I think you're meaning a finished firearm that was homemade, or a
Correct.
firearm manufactured by an unlicensed subject, if I want to use that term.
Right. How do you make that back to an 80%er or make it so it's not defined that it could be
A gun?
any part of a weapon other than cutting it in half?
So you're referring basically to the proper destruction of the firearm.
Disassemble of a firearm.
Oh, so you disassembly only, okay.
Okay, or if you're just talking about disassembly, you're not going to be able to do it because once you've manufactured that into a firearm, it's now a firearm receiver, is determined to be a firearm for very specific purposes under the penal code and under federal law as well. Once it's a firearm until you destroy it and make it no longer a firearm. So literally, just disassembling the parts is not going to make it no longer. Once you, if you take an 80% lower and you've got the plane on the top of the 80% AR-15 trigger group area, if you just drill a little hole there, you can't fit anything in there, but the ATF has determined that that's a firearm for manufacturing purposes. So that in and of itself is a firearm. The only way I can make it no longer a firearm is to destroy the firearm. The ATF does have guidance documents on how to destroy certain kinds of firearms, like machine guns, and they require blowtorches or certain kinds of machines that you have to cut it at certain widths. Those really apply specifically to those specifically apply to machine guns and other NFA type items. It's been traditional for people to use those methods to destroy firearms generally too. So, but you're going to have to destroy it, not just disassemble it in order to make it no longer a firearm.
Thank you.
And then you'd have to inform, the proper way to also do this is you notify the DOJ that you're no longer in possession of the firearm through destruction, and forget the exact number of the form, but essentially you indicate that it was destroyed and you have to show evidence of its proper destruction. That usually will be a sworn statement by a manufacturer, FFL, that will state that the firearm is no longer able to be repaired or fixed back into a firearm, and that it was actually destroyed.
If your gun's already in the AFS.
Yes.
So don't register.
You may have to.
Self-help.
Okay, I'm not that's not my question. Actually, as regards to penal code, I think, Colonel, you kind of touched upon on 25-850 when it talked about G in itself. And, but basically, it's kind of like, it's a penal code about crimes for carrying loaded weapons. And then following that, there's 26035, which basically says it relates to a person engaged in lawful business to have a loaded firearm if authorized. So that means, what I interpret that to mean is that an employer can authorize an employee to carry a loaded firearm on those premises.
Correct.
Is that correct?
Yes.
Now, what is
Unless
that?
you work at a school.
Yes. Okay. So what is that authorization? It's just a simple letter?
It's probably best to, I'm sorry, that was directed at you, I'm
Yeah,
sorry.
he can handle it, because I'm not always doing the California law. Yeah, I get more Texas questions, quite frankly, so he's going to be, I read it last night, but I am not the expert in that. But you're going to want something that's more substantial, I would think, than a letter.
Would it be a letter on letterhead? What else could a business
I
do?
would say get a letter on letterhead is
Yeah.
the best way to do it. Keep that for your files. That way, in case they ever revoke their license or revoke the permission, you can say, well, I've got this letter up until that point. And I would.
And that's without a CCW, that's
Yeah.
what I'm talking.
I would
Yeah.
also request, if you do write the letter, that you have something in there that says the authorization has to be revoked in writing. That way, they can't just say, I revoked it before. and then now all of a sudden, you never told me that you revoked it. You want to be able to have the revocation in writing. That way you can document it yourself.
I'd also recommend the letter be emailed to you, not
Timestamped.
not
Well, I would
typed
think
up.
that the letter would need to be on file at the place of business.
Yeah, I was going to
Yeah,
add
but
that.
I-
Make sure there's copies made to where your employer has a copy of the letter and you
Right.
have a copy as well.
Okay.
Just to jump in here, well, obviously as an FL, we have a lot of people carrying firearms that I authorize. One of the things that the law does say is that you have to, that person that you're authorizing to carry a firearm has to have the authority to deny business. So it can't, so unless, I guess, the janitor who's sweeping up the place has the authority to deny business, that technically wouldn't fall under the letter of the California law. So just be careful in there, make sure you read the law and understand what you're doing.
I would also recommend that the employer, if you're the employer, you check with your lease agreements, because a lot of lease agreements, especially in certain cities that are controlled by one company, a lot of companies actually control a lot of the rental agencies and locations within a given town, have firearm prohibitions in their lease agreements too. So you don't want to be voided by the fact that the lease agreement never allowed them to have that authority in the first place.
Right, I understand. Then this would be private, strictly
Yeah.
private property. And specifically, it's in standing up a church security team. So this is private property within a church. So I didn't read anything in there in regards to churches not being able to have this type of a
Is the church in
situation.
school? Sorry.
Yeah, I would just say, I would be very careful when you're talking about a church security team as like more of a formal operation, because arguably, although a church can be privately owned, they generally don't restrict access, meaning most people can generally walk in from the street, public access to attend services. So you got to be very careful with what's really going on and how this is all structured, and it's not something to just jump into. A lot of diligent research needs to occur
Actually, sir, let
before.
me talk to you offline. I
All
happen
right.
to have a
Be
security
great.
company. Churches actually fall under BSIS, the Bureau of Security Investigative Services in California.
Okay.
You will be required guard card, but I can walk you through all that.
All right,
Work
great,
with you.
thanks a lot.
Exactly.
And one
We'll
of
talk.
the other things that we see a lot with, especially with church security, is a lot of churches have schools on their grounds. And if you have a private school on those grounds, even if the school isn't in session, you can be in violation of the penal code sections dealing with firearms on school grounds.
Can't carry a firearm within 1,000 feet of the school.
Maybe better to see if you have actual law enforcement officers that are, members of the church, and discuss with their agencies whether they can be permitted to carry, while they're not on duty, and go maybe look down that road in an unofficial, non-security team basis.
Right.
That might, because like he said, as soon as you get into official security teams or anything like that, BSIS and guard cards and all sorts of
Yeah,
other
yeah,
restrictions
you
occur.
got to get a different name. I understand what you're talking about.
So
All
we
right,
can talk
thanks.
offline.
We'll
All
talk.
right, thank you. Sir?
Gentlemen, thanks for doing this. It's been fascinating. I think it was John Dillon who brought up the Fourth Amendment thing about the DOJ possibly showing up as part of the registration process if there was something they had a question about. Can one of you expound on where my Fourth Amendment rights, do they show up under power of warrants? I mean, I realize you're kind of wrangling smoke at this point in time, but what might be a best guess?
Here's something.
Wrangling smoke.
I like that a lot.
I'm going to write that down.
Very generally, law enforcement can, they call it a knock and talk. They can show up at your house at any time for any reason or for no reason at all and ask to talk with you.
And DOJ would be doing that as opposed to SDPD or sheriff?
Well, it depends on the circumstances, but if it's in the context of a registration, most likely they would say, if you want your registration to go through, you need to answer our questions. And if you don't voluntarily allow them to inspect your firearm, they'll go to a judge and most likely get a warrant to inspect your firearm.
So my question was kind of, if they need to inspect further on site, is this the sort of thing where we can expect just an out-of-the-blue visit? Or is that something where they would make an appointment? Do you see us maybe having
Your
a
notice
choice?
is usually the,
Yeah,
that's generally what
just
you
to
need.
clarify.
They're not going to call you ahead of time and say, hey, we noticed there's an issue with the registration of your firearm. It may not be compliant or legal. We're going to show up at your house on Wednesday at 1 o'clock to talk about this. just in case you are, a felon. It just won't happen.
And just so you know, most states look at this as a Fifth Amendment issue. A Fifth Amendment issue, so they don't require registration, because you're literally incriminating yourself with any kind of thing you say. And so a lot of states are like, appeals courts have held this too, that registration's a no-go because you're actually incriminating yourself in a crime. And so when you see stuff like this, you guys are like, okay, the registration, how do we follow the rules? But most other states are like, what are they, crazy that you have to register a weapon? That is unconstitutional. So it's really unusual I hear it and I get it, and you got to follow it until we figure it out. But
Well, it seems that administratively, probably more likely situation would be, we've seen people can't take pictures for crap. So wouldn't it be more likely that they'd show up, your pictures weren't clear enough, that
They'll
sort of
email
thing?
you
We'd
those.
like to inspect it further,
If
take
More
our own
likely, if
pictures.
it's just the quality of your photos, they'll send you an email and ask you to
Better
send new photos. Or they'll reject your application for registration altogether and tell you that your photos weren't good enough.
Gotcha.
More likely, the only reason that they would come to your house is if they think that you have an illegal weapon.
Okay, all right, cool, thank you.
And just in general, I've talked to a lot of people already who have, done a registration, and they have been emailed back from the DOJ saying, hey, we want better pictures of here. I've heard of DOJ asking, okay, well, what is the manufacturer of this part? What part is this? Only give them the information that is required by law. A good general example. A lot of people, you get in trouble when you try to explain yourself without proper representation. So,
Okay, these will be the last 3 questions.
All right, my question is, you said that with the AB 857 that passed, that July 1st, 2018, if you plan to assemble, what if you don't plan to assemble your 80% lower? What if you don't plan to make it a firearm? Can you just say, I don't plan to make it a firearm, and leave it alone?
oh, so you're talking about an 80% receiver that you have not
That's-
done any milling to or
Correct.
touched in any way. So when it means plan, it's truly you are intending to mill that firearm out and create or 80% out and create a firearm out of it. And that's why, after they get you the serial number, you have a certain amount of time to actually create the firearm. If you just have an 80% receiver, like Jason said earlier, it is not a firearm. It's not a
Okay.
regulated item.
That's a
but
paperweight.
Yeah, it's a paperweight, but you cannot make any progress whatsoever on actual milling or changing.
So any little bit of progress, you are planning to assemble?
Jason mentioned hold. Arguably, if you just start a drill and don't even make a hole, but just make an indent at that, that
Okay.
fire control cavity, area, that's arguably a firearm now. So just do not
Got
do
it.
that. Don't touch it.
And is,
Well, you said it's planning, so if they could get you for attempted, but that's they're gonna have to prove that you were planning on doing it anyways, and regardless of whether or not you actually did it. So if they came in, they said, hey, so what were you doing with this? Well, I was gonna go ahead and drill this. Were you gonna get the number? No, I was just gonna do it anyways. At that point, you kind of deserve it.
no, to their point, the more you talk, the more you're going to convict yourself. It's just like people who are law-abiding citizens want to explain things.
I
Criminals
don't.
don't explain crap. They're like, time out. But everybody else is like, oh, I'm a law-abiding citizen. I'm going to tell the police officer what's going through my mind, and it'll all be great.
and can an
no.
answer to this be to take it out of state?
No, you're going to take that one.
Okay.
I would not take it out of state.
No, it is a firearm, so
Okay.
let's say we've made it a
It doesn't-
firearm, can we just send it out of state?
So if you've already made it a firearm, and let's just say you made it before the June 31st last day that you could do it, so before July 1st, and you take it out of state, well, that doesn't negate you from the fact that you still had to register it prior to January 1st of 2019. These dates are already messing with my head, but prior to January 1st, 2019, you're still going to have to register it even if you've already manufactured it. So if you took it out of state, would it negate that? No. Would they know? It's one of those things that they'd have to somehow figure out that you did it and then figure that out within the timing of the statute of limitations. But could they come after you if you did that?
Well,
Yeah.
And let's also be very, very careful about the word sending it out of state.
Exactly.
Be
Yeah.
very, very careful. It's one thing
Okay.
if you're shipping it to your house in another state, It's another thing if you're shipping it to somebody else. in
To my
another
brother, let's say.
Yeah. no.
No,
That's a
no,
gun.
we can't,
Okay.
yeah.
Big
All right,
Through
Yeah,
dealers.
That's
All
a
right.
no-go.
good.
And I'm sorry, before the next question, I just wanted to make one more point that I'm sure everyone in this room, I don't want to make it seem like a truism because it's not. Truly is the truth. I'm sure everyone in this room supports law enforcement, but talking to law enforcement is never going to help you. It's not their job to get you out of trouble.
Right.
Remember what Reagan said? Was it, "Hi, I'm here from the government. I'm here to help you"? Is that,
There's actually a great YouTube video. I believe it's "Never Speak to the Police" is the title of it. It's a law professor and a chief of sheriff or chief of police they do an hour and a half long lecture on why you should never speak to police. And this is a law enforcement officer, or retired, I believe, talking about this, and a law professor, a criminal law professor. It's an hour and a half long. It's a long video. It's detailed, but it is really, really important, and also a great video to truly understand the ways in which you can incriminate yourself even when you're an upstanding citizen, good person, just by talking. And it really mess with you. They go over the ways in which police know how to get people to talk, one of which is just standing in front of you and being quiet. You don't say a word. People don't like awkward silences, so they start to talk after it gets uncomfortable. So it's a great video. I always recommend it to people. A good general source of information. It just really highlights the problems that can happen.
Sorry to cut you off.
I have a question about home defense or self-defense in your own home. You were speaking earlier about if someone came in and stole something or they were walking out and didn't have intent to harm you. But what if someone broke into your home, your door was locked, someone broke into your home, and let's say you saw them and they had a weapon, or a firearm rather, and you also had a firearm that you had in your home, and you drew your firearm upon them, intending to kill them because they had a firearm on you. What if their firearm was not loaded
doesn't matter.
and yours was, and you shot them?
That goes to what John was talking about with reasonableness. Was it objectively reasonable for you to believe that your life was in danger? And most
al-
likely, yes.
Also, get rid of the words, I intended to kill, okay? Like, erase that completely out of your mind, okay? What you were doing is, there I was defending myself. I had fear of imminent death.
And that is why you don't talk to the police
Exactly.
after that happens.
I mean, like, you'll hear 911 calls, like, and the operator will ask questions like, well, so how many shots did you fire? 3, 4, I don't know. I emptied the clip, then I reloaded. I mean, you get all sorts of, it is not a good time to be answering those questions.
Right.
And just to be clear, he didn't even have to have a gun for you to have reasonable fear. The doctrine says that you've got a presumption of reasonableness unless there's something else that can overcome that presumption. Like for example.
Presumption.
Yeah, for example, if he says, "Sorry, I'm leaving right now," and puts the TV down and starts to walk out, at that point, maybe it depends. Is he headed straight towards the door? Is it possible that he could be running upstairs where you have your kids sleeping?
Right.
There's still a lot of these factors that play into it. It's just it's a presumption that you acted reasonable.
We're talking about the totality of the circumstances, what they, this is how it's, interpreted. So they will literally, go over all of the different circumstances and facts of that night, of what was happening, of, what he had, what you had, everything. Whether it was dark, whether it was in a hallway,
Right.
were your kids in between you
Right.
and the intruder, all of that comes into play. And so all of that will be used to determine the reasonableness of.
And for everybody
And your
here,
character.
Alan's going to be putting on or having a discussion later after the other panel's over about this very topic. So hang out for that. You'll get a little bit more clarity.
Thank you very much.
Hello, gentlemen. Thank you for providing the service. I have one question I wanted to touch on. I don't think we've hit yet. It's an important one, but first I wanted to go back to Christy's question. Hello. I just wanted to clarify your answer to that. Let's say I manufactured a firearm before the prohibition went into effect, and I do not intend to register it by the 1st of July.
You're asking for a friend, right?
hypothetically.
I'm just asking for myself, really, but yeah. I can do that.
You have the right to remain silent.
So
do we
taking
send
that
the bill?
firearm out of the state is not enough to not have to register it? Is that correct?
It says if you've manufactured in the state. Did you?
In this state, yeah.
Yeah, okay.
Yep.
There you go.
So even if you remove it and you don't possess that weapon
If
here,
I
it's
possess,
still necessary?
if I possess an assault weapon in this state,
Yeah.
and then I leave the state, I still violated the law. I should say unregistered assault weapon past the registration deadline. I violated the law. It doesn't mean that taking it out negates that. If I'm speeding on my way to Vegas, and then on the way back, like we saw you speeding, we got a picture of it. Here you go. Here's your ticket. You still violated the law then. It doesn't negate the fact that that law was violated. Now there's a statute of limitations that they have from which they can prosecute you.
Does it not say within that law that one of the exemptions for not registering it is removing it from the state?
If there's an exemption for that, then yeah, you can go ahead and remove it from state. I'd have to double check it. It's been a while
Okay.
since I've looked at it.
Okay, so now
just
for my
don't come
question.
back.
I think this might be one of everybody's questions in the room. As far as the normal capacity magazine prohibition, where the injunction is right now, do you have any status on that, or what's going to happen with that?
Last I checked, it was still in place.
Yeah.
Okay,
You're
and-
talking about Duncan v. Becerra, and also there's one at LA too, I believe.
I think it's the
Two
Becerra one,
different-
or the-
Becerra one is still going on.
Duncan.
So,
They're both still going on, but
yeah, so the injunction is still running, but remember, once it gets settled in court, it's not like there's a big announcement.
Yeah, it's just back in effect, right?
Yeah, so
We're all
if
criminals.
the injunction ends up getting overturned, then the law just is in effect. So
Okay,
anyone who has, legally possessed so-called high-capacity magazines, you need to take necessary steps to address that fact that can occur.
and I want to point out, one of those necessary steps is not disassembling them, because if you disassemble them, now you're in possession of a large capacity magazine conversion kit. So,
got it.
Remember,
And if you put it back
permanently
together, you've
altered is a
manufactured
good thing to rely on. Permanently altered.
Gotcha. How do we get in touch with you guys if we want to solicit your services, or is there a
We have
business
cards.
Yeah.
Cards are at the
up
back of the
there.
table.
Essentially, you can pretty much type in any one of our names on Google.
Okay.
Firearms, guns, Second
Yeah.
Amendment. That should
follow me at calgunlawyers.com. I'm
Okay.
going to give the plug.
CAFirearmslaw.com.
So we don't want anybody to leave. We got some more to cover, but we have a 5-minute break just to let everybody shuffle around, stretch your legs a little bit, and then we're going to bring a new panel up here and keep going. Thank you all.
Without someone doing something about it, it's not going to get any better.